In today's video, we're going to talk about the statute of limitations on collecting debt. This will go for original creditors and debt collectors. And I believe that this video is timely because you see news reports, you see blog articles, news articles talking about the statute of limitations on collecting debt and how some people have been taken advantage of by debt collection companies who were collecting debts that they did not have to pay. So now, before people start to say things like pay your debts, pay your bills, you won't get in trouble if you pay your debts, that is fine and well and good, and I believe that we should all pay our bills. But sometimes life happens. And just in case you want to know how the economy is doing, I have an image right here that shows that delinquencies are flat. Now, this is not a report from me. This is straight from CNBC, where they had interviews with the various credit card companies, auto finance companies, even subprime companies. And they said that delinquencies are flat. So this means that most people are trying to pay their bills. Most people are paying their bills, but life happens. And that's why I wanted to make this video, because life has happened to a lot of people, and some people find themselves in the situation where they just did not pay certain debts. And we've all been there, so I'm not taking myself out of the equation. And I want to give you some very valuable information that will allow you to be able to move forward if your debt is past the legal statute of limitations to collect. Now, what is the statute of limitations when it comes to debt? Some people know this, some people do know this, but the details are kind of gray. When it, like, if you think about it, it says, okay, you can't collect this debt because it's past the legal statute of limitations. And people will say, well, what is a legal statute of limitation? Well, each state has a statute of limitations when it comes to debt. Now, there's different categories, which we're going to go over in this video, on certain debts can have a shorter statute of limitations period than other debts. And then you might be asking, well, when does the statute of limitations start? We're going to talk about that also. But the main thing to understand is that if a debt is past the legal statute of limitations to collect in your state, the state that you reside in, the original creditor or a debt collector, neither one of them can collect that debt legally from you. They can contact you to see if you would like to pay, but they cannot take any legal action to make you pay. That is the number one thing that you got to keep top of mind. So now let's go into the different states, and then we're going to go into the time frames for each state. So let's start with Alabama. Let's start with the A's. Where is Alabama on here? And as we go through it, I want you to just think, what do you think the statute of limitation is for Alabama? So Alabama, for where we at? Alabama, here we go right here. Alabama, for oral contracts is 6 years. For written contracts, which is what most of you are dealing with, written contract would be something like or a promissory note would be a loan that you got, an installment type loan. So it's 6 years. We got a 6-year statute of limitations for promissory notes, but check this out. For credit card debt, for open-end accounts, revolving accounts, it's only 3 years. So you look at 3 years on that debt. So let's go to Alaska. Where's Alaska? Right here. What do you think Alaska is? What do you think Alaska is if you live in Alaska? It's cold in Alaska. They should pay your bills in Alaska because it might be hard to work in Alaska. No, my cousin was in Alaska when he was in the Army, and I was like, was it always cold there? He said, surprisingly, it was not always cold, but he did say that for 6 months it was daytime. And I was like, I don't know how I could deal with that. So for Alaska, you got 6 and 3. Now, let me tell you something that's different about Alaska that you might not be aware of. Now, promissory notes. Now, if you've ever gotten a loan from Lending Club and some of these different types of fintech companies, you will notice that they're using the term promissory note, that they're not a written contract. And in Alaska, for a promissory note, guess what? There's a 3-year statute of limitations on a promissory note. Now, let's go to the next one. We got Arizona. For oral contracts is 3 years, which the other ones were 6. For written and promissory notes for Arizona is 6 and 6. But for open-end debts, like credit card debt, anything that you can revolve is only 3 years. Let's go to the next one. Arkansas. You know, I'm glad I paid attention in school, because I would be all over this map. I would be like, where's Arkansas? Where? So we got Arkansas. Arkansas for oral contracts is 5 years, written 5 years, promissory notes 5 years, and we have 3 years for credit card. Looks like we're getting, something seems to be very familiar with each state with these open-end contracts. So now let's go over to the big state of California. For oral contracts, you have 2 years, and then you have 4 and 4 for installment loans or contracts and promissory notes. Also, just coming to my mind, one of the big reasons why there's a big difference between written contract and promissory notes is that they wanted to had it defined kind of different, because a promissory note is going to usually be something that was loaned out to you. But written contracts could be between individuals. And also, you notice that some of the contracts, even when you buy a car or something like that, it'll say written contract. It won't say promissory note. But I have seen one that said promissory note. Now, for California, for open end is 4 years on open end. So now we're going back up. So now let's go to the state of Colorado. We have 6 and 6 for the written and promissory note, and then we have 3 for open-end accounts. Now let's go to Connecticut, way over here. We're going way over to Connecticut. We have 3. So we have 3, 6, and 6. I'm sorry. The oral contract is 3. The written and the promissory note is 6. And then we have 3 for the credit cards. Let's go over to Delaware. We're way over here on the East Coast. So for Delaware, we're at 333. So here we go. We're going to move that down here. For written contracts, we're at 3. For promissory notes, we're at 3. And look at this. For open-end contracts in Delaware, we're moving back up to 4. So you actually get a benefit of the written and promissory notes, but you get a penalty in Delaware for the open-end type debts. Now let's go to DC. DC is 333 across the board. Where are we at here? This is getting, boy, we got to covered up some of the stuff. So DC is 333. So written contract 3, promissory 3, and open end is 3. Let's go to Florida. Florida is 5 and 5 written and promissory notes, and 4 for open end. Let's go to Georgia. Georgia is 6, 6, and 6. So you're at 6, 6, and 6. Promissory note, written contract, promissory note, and open end accounts in Georgia. Let's go all the way back over to Hawaii, which is down below here. Hawaii, we're at 6, 6, and 6, and 6. Let's go to Idaho. Idaho. Where's that? We got 5, 5, and 4. 5, 5, and 4. To make it easy, the way I'm going to do this is written, promissory note, and open-end debt. Let's go over to Illinois. Illinois, we have 10, 10, and 5. So I'm going to take a quick break here. We're at Illinois. So I want to talk about some things real quick just to make you aware of it. One of the misconceptions that a lot of people have when it comes to debt that is past the legal statute of limitations is that they think that that's also past the statute of limitations to show on their credit reports. That is not true. The statute of limitations for reporting is different from the statute of limitations for collecting debt. For reporting on your credit reports, it's a 7-year statute of limitations on a negative or positive account. On a negative or positive account. Statute of limitations for collecting debt, it pertains to the Fair Debt Collections Practices Act for original creditors or debt collectors who are trying to collect a debt from you. That's when all of these different statute of limitation time frames would come into action. Also, if you have a debt and you might be wondering, well, when does the clock start ticking? What does it actually mean? When does the statute of limitations start? One of the biggest misconceptions that I've seen out there is a lot of people thought that the statute of limitations started when you had the account. No, it starts on your last payment from your account. And this is an adjustment from what I used to tell people. We had always went by the charge-off date because we were like, it's still an active account until it's charged off. But actually, the way that it's written in the Fair Debt Collections Practices Act and the CFPB, the Consumer Financial Protection Bureau, has made an update where they said from the date of the last payment. So even though you haven't made payments and it's not charged off yet, and it can kind of be teetering between an active, non-active account, it hasn't been closed out yet, if you did not make a payment from that date, that's when the clock starts to tick, because it is their responsibility to collect on that debt within that specific time frame. So now let's get back to it. We just finished with Illinois. Let's go to Indiana. Indiana, right next to Illinois, is 10, 10, 10, and 6. 10, 10, and 6. Let's go over to Iowa. Let's shoot over going towards the west here. Where we at? Iowa, there we go. Iowa, 10, 5, and 5. So we got 10, 5, and 5. So we got 10 on a written contract. We got 5 on a promissory note and 5 on a credit card debt. So let's go over to Kansas. Going right below there, we got 6, 5, and 3. We got 6, 5, and 3. Let's go to Kentucky. This is going to surprise you when you see this with Kentucky. This is going to surprise you. Kentucky is 15, 15, and 3. So if you're in the state of Kentucky and you have a promissory note, if you're in the state of Kentucky and you have a written contract, there is a 15-year statute of limitations on that. 15 years. 15 years. Just think about how long 15 years is on there. I guess in Kentucky, they hold grudges in Kentucky. But you do have 5 years on the open-end credit card type debt. Let's go to Louisiana. Now, when I show you Louisiana, too, you're going to be like, man, something is strange about these southern states. You have 10, 10, and 3 for Louisiana. Let's go to Maine. We're going way back over on the East Coast. We have 6, 6, and 6. So we have 6, 6, and 6. I don't want to hear nothing about that 666 stuff. Let's not get into all of that type of stuff. Let's go over to Maryland. We have 6. We have 3, 6, and 6. We have Maryland. We have, it's stuck up in here, but we have 3, 6, and 3. And we have some asterisks right here with Maryland. There are some different changes that may be about for specific types of debt where the statute of limitations could be extended, or it could be shortened. Let's go over to Massachusetts. We're going way back over to the East Coast again. These are just all stuck up in here, but we'll go 666 again for Massachusetts. And then we got Michigan. Over to Michigan, we got 666. I can already hear it now. We got a lot of 666 on here. Let's go over to Minnesota. We got 666. Maybe the same people, you know, they were cousins when they wrote the laws for statute of limitations. Let's go over to Missouri. We have 10 and 5 on Missouri. Let's go to Montana. We have 8 and 5. Montana has 8 and 5. 8 and 5. A strange number on that. Let's go to Nebraska. 554. 554. Let's go to Nevada. Over in the gambling capital of the world, we have 6, and we have 3, and we have 4. I'm surprised that Nevada doesn't have a shorter statute of limitations just across the board, you know, because of the type of stuff that's going on over there. Let's go to New Hampshire. We got 3, 6, and 3. I'm just going to write these over this way. 3, 6, and 3 for New Hampshire. We got New Jersey, 6, 6, and 3. New Jersey has made some adjustments to theirs. They've actually, they're very consumer friendly when it comes to collection of debt and making sure that debt collectors state that they're not trying to collect the debt that's past the legal statute of limitations to collect. Let's go over to New Mexico. We got 6, 6, and 4. Let's go over to New York, 3, 3, and 3. New York is also very aggressive on making sure that any debt collector who files a case must abide by the statute of limitations. They actually make them put that in their court summons for that when they're trying to sue for debt. North Carolina, we got 3, 5, and 3. 3, 5, and 3. North Dakota, we're going to shoot back over this way. We have 6, 6, and 6. See, I told you, some of these people, they're related to each other. We got Ohio. Ohio, if you live in Ohio, you're not going to like what I'm about to put here for Ohio. We have 15, 15, 15, and 6. They must hold some grudges in Ohio. Let's go over to Oklahoma. Go over to Oklahoma. We got 5, 5, and 3. All right, let's take a quick break on the map real quick, and let's talk about the legal actions that debt collectors or original creditors, what they will try to do when they're trying to collect the debt and they know that it's past the legal statute of limitations to collect. Now, an original credit, well, I'm going to take that back, because let me tell you a quick story of something that happened about 6 months ago with the client of the credit repair shop. This young lady needed to make a settlement on a credit card debt. She had just recently got married. Her husband was demanding, like he said, he came to us and we fixed his credit. And he sent her to us and he made demands, like, you know, sometimes the husband be like, I demand you to get this taken care of. She came to us, she said, my husband said, I got to get this taken care of. And I said, well, you know, I don't want to make any arguments. I don't want to tell you what to do. You might want to listen to your husband and let's fast track this issue that you have with this credit card debt. Credit card debt had been on her credit as a charge-off since 2019. So it wasn't past the legal statute of limitations to collect. But wait, let me back up. It had been on her. Yeah, it was not past the legal statute of limitations to collect. But when we called to try to do a settlement. We did a three-way call, tried to do a settlement. The operator or the representative for the credit card company said something that piqued our, brought our antennas up. And the representative said that the debt, that you do not have to pay the debt. So I was like, we need to double check. Well, she didn't say it that way. She just said that by you paying this debt, because we were about to do this transaction, said by doing this debt, you understand that you did not have a legal obligation to pay this debt. And it was like, only time we've heard that is if you were paying a debt that was past the legal statute of limitations to collect. And I said, pull up a report. We told the representative, we said, please hold. We need to consult with our client, and we wanted to pull up her reports to see what was going on the reports. And we was like, this is not past legal statute of limitations to collect, so what's going on with this? And it turned out that credit card company had filed a 1099-C to the IRS. So that amount was being reported as income to our client, but our client had not gotten the documents yet. Now, that was that situation. Now, another situation was where when dealing with a third-party debt collector, they would say on the phone, talking with the client, they said, we're attempting to collect a time-barred debt. And it was like, what do you mean? The client called us back, said, they said that they're attempting to collect a time-barred debt. And we was like, well, that means that the debt is past the legal statute of limitations to collect. And they have to notify you that the debt is past the legal statute of limitations to collect. Now, with original creditors, they will never call about a debt that's past legal statute of limitations to collect. I won't say never, but I've never heard it happen. And it's usually where the debt was filed in a 1099-C, and they tried to, collect on the debt, which they have a right to collect on it. In both situations, they have a right to collect on the debt. They can, but they don't have any legal leg to stand on forcing you to pay the debt. But here's something that you need to be aware of. If a debt collector calls you for a debt that's past the legal statute of limitations to collect, and you may not know that until you actually look over your credit reports to see what's going on with that debt, they have to say that this is an attempt to collect a time-barred debt. They have to use that wording in their whatever script that they use to call you. They have to say it. It is required for them to say it. If they don't say it, they are in violation of the Fair Debt Collection Practices Act. They have to say that. And I've even heard it to where they said you have no legal obligation to pay, but you have a moral obligation to pay. When they say that you have a moral obligation to pay, or you may have a moral obligation to pay, I consider that harassment when they are calling you on the phone saying that you have a moral obligation to pay a debt. This was a tactic that was used by a major credit card company on a certain community where the individuals did not, they ran into some problems. They're from another country. Their religion says you have to pay all your debts, and they would use the religion against them, and they even took it a step further, and they hired people who knew their religion. So when they called them, they would insinuate, hey, you got to pay this. They would insinuate, that you have to pay it. You know the reason why you got to pay it. They wouldn't exactly use the words, but when I would talk to my clients, they would say, man, this guy, he knows my religion. He knows that I got to pay this debt, that I can't just leave it out there. And I would say, it's your call, but you do have a right to negotiate that debt. And that's what we ended up doing for them. So now let's move on. Let's move on. Where did we stop at? We had Ohio, Oklahoma, and let's go to Oregon. Oregon is 6, 6, and 6. Just in case you're coming in late on the video, the first 6 is for contracts. Second is for promissory notes. third is for open-end accounts like credit cards. And again, we got a lot of 666s on here. So there was a lot of people that are related to each other, or maybe they were just sharing information on, hey, what is your statute of limitations? That sounds good. We're going to make ours that same amount of time frame. So we got Pennsylvania as 4, 4, and 4. Let's go over to Rhode Island. We got 5, 6, and 4. I'm going to stick that just over here. 5, 6, and 4, running out of space over here. Rhode Island is right there. We got South Carolina. We have 3, 3, and 3. We have South Dakota. South Dakota. And it's only because it's in south of North Dakota, because south would be down here, right? We got 6, 6 is 6. So we got the cousins here. The cousins for North Dakota knew, they told their cousins down in South Dakota, which told their cousins from Minnesota, which told their cousins from Michigan, which told their cousins from Georgia, which told their cousins all the way over here in Oregon, and told their other cousins, where we got another 666, right here in New Hampshire, in Maine. All of these people are related. All right, I'm just joking. Let's go to Tennessee. We have 663 in Tennessee. So 6, 6, and 3. We have Texas 444. Let me talk about Texas real quick. One of the calls that I will get a lot about Texas is about their in Texas. This is the thought process in Texas, and I'm actually from Texas, born and raised in Texas. One of the thought processes in Texas is, number one, we're the biggest state in the United States. But the other thing is that you cannot garnish someone in Texas. So that you can't do a wage garnishment. So in Texas, people feel emboldened not to pay it. If they're behind on a debt and they can't pay it and they're in the situation, they look at statute of limitations, but they also believe they have an extra layer of a statute of limitations because they can't garnish their wages. Well, let me just tell you what's been happening in Texas. They've been doing severe, and you can look this up on news reports, very severe bank account seizures, where people wake up in the morning and the money is taken out of their account. So be aware that just because the statute of limitations may be short, statute of limitations may be short and they can't do wage garnishments. A lot of people in Texas choose to try to wait it out. There's actually some judges that actually tell people to try to wait it out because you only have 4 years that they would be able to collect it from the last payment date. But you got to be careful. If it's between those periods, they do have the right to take legal actions to be able to collect on the debt. Let's go over to Utah. We got 6, 6, and 4. 6, 6, and 4. Let's go over to Vermont. We're going to work our way back over to the East Coast. We got 6, 5, and 3. I'm just going to stick it. We got 6, 5, and 3 for Vermont. We got Virginia. We got 5, 6, and 3. It's all stuck up in here. So Virginia, 5, 6, and 3 for Virginia. And we have Washington, 6, 6, and 3. Let's go back over here to the 6, 6, and 3. And we have West Virginia at 10, 6, and 5. So West Virginia, we have 6, 10, and 5 for West Virginia. And then we have Wisconsin, my state of Wisconsin. We have 6, 10, and 6. And then we have Wyoming right here, last state, Wyoming. Oh, I'm sorry, we have Virginia right there. I don't know, for some reason I thought Virginia was up in this way. We got Wyoming at 10 and 8. So let's do a quick review. So hope you enjoyed this. Look at that map all on there. So let's do a quick review. The time frame for collecting debt the time frame for statute of limitations. We just went through the different time frames that it is for each state. So you can see that it varies from state to state. So the clock starts to tick from the last payment that you had. Starts to click from the last payment you had. It does not matter if they try to sue you and you find this out later. You can put that in your summons response that this debt is past the legal statute of limitations to collect. In some states, they do require the debt collector to clearly state in their summons that they know that this debt is not past the legal statute of limitations to collect. Other states do not require it, and that's why you'll see some lawsuits go through and the debt was past the legal statute of limitations to collect. I am my own testimony from something that happened to me when I was in my 20s. I had a credit card from when I was in the U.S. Army. The total amount that they probably gave me was $150 available credit. I was not making a lot of money at the age of 18 in the U.S. Army. I ran into money trouble, flat out. I'm just saying it. I ran into money trouble, did not pay the card. Years later, I was sued by a debt collector. And I knew that I did not have, they said it was $4,500. And I said, there's no way that I charged up $4,500. There is absolutely no way. But this was a lesson to help you with the credit repair shop. This was a lesson. If I would have just known that when they came to try to collect that debt from me, that it was past the legal statute of limitations to collect. Yes, not knowing what I know now, I went into court and I just said, hey, I did not charge that amount. I did not have a debt for $4,500. I knew that, like, maybe the way that I said it, the judge and they had an attorney there, but that didn't end up being the attorney that I ended up dealing with when I pushed this forward. I said that this is not my debt. I mean, this is not the amount. I had the account, but I know I didn't do $4,500 worth of charges. And I said I want them to prove that I did. They sent back this Bible of documents, and everything was redacted except for my name and the account number, or partial credit card account number. And I said, still, that did not prove that I had $4,500 in charges. And then the judge made another hearing, and with that information, I said, the judge said, well, you know, I think the judge knew that I was on the right track, but the judge couldn't help me in it. And I said, well, let me go into the room and talk with the debt collection company, which was the prominent Roush, Stern, and Hornick when they were first getting started. I was right across the table in my 20s from Attorney Roush. And I said, I don't have that amount. And he said, well, you can make payments on it. I said, no, I'm not making payments. I didn't charge $4,500. He said, well, how much do you think you might have charged? I said, at the most, and I just threw this number out there. And this is a lesson. This is a lesson. I'm going to put this in a video yesterday, but this is a lesson. I told him the amount that I potentially maybe had charged. And I said it was probably $500. I don't know where that number came out at, but I said it's maybe $500. And he said, okay, we'll settle the debt for $500. Went back out in front of the judge. We have a settlement, $500. I took the $500 to the attorney's office. The representative there was like, he wouldn't have settled that for $500. I know. And then he pushed, I said, call him. He pushed the rep aside and said, here, where's the check for $500, and took it. And I made a video yesterday and I said that you will get better settlements when you deal with the attorney because the employee is doing exactly what they're told to do. But when you're dealing with the owner of any business, you're going to be able to work out different types of, when it comes to dealing with debt collection companies, when you're talking with the attorneys, you're going to be able to get better settlement offers on that. But the lesson from that is that I didn't even have to pay that amount. I didn't even have to pay $500 because it was past the legal statute of limitations to collect. It was originated in Texas, and I was living in Wisconsin, which was 6 years. It was past the 6-year statute of limitations, so I would not have had to pay it. I would not have had to pay it. But that was just, it was a lesson for being able to help you out right now. So another question that people will ask me, they will say, well, if you were in Texas, is where the loan originated, but you live here, can you go off of the statute of limitations for where the loan was originated, where you originally got it? And what I've always said is, hey, you might as well throw that at the wall and see if it sticks, because remember, the debt collection companies are not usually located in your state. So they may be afraid of, if we go and try to sue this individual here, and we're way over here, this debt collection company's over here, so we're going to try to sue him over here. The debt originated here, and we're going to be talking to a judge, and we're way over here. You never know. That judge might say, well, you're not even in this state. You don't even know how the laws work in our state. This type of stuff does happen. Like, even though we're in this Zoom, this new Zoom type court system, the judges still, for some reason, they will say things like, well, this is how we do stuff over here. Even though the law is a law, but you'll hear words like that. Well, over here, we do it this way. You're over there. And so the debt collection companies, they can be a little afraid. So you can throw that. You can say, well, hey, the loan originated there. That is past the legal statute of limitations. It was past legal statute of limitations before I moved up here. Whatever fits to make your situation look the best, you can utilize that when dealing with the statute of limitations. Now, we just talked about the different types of debt. We have our contracts, we have our promissory note, and we have our open-end accounts like credit cards. And I didn't go too much into it, but there is a statute of limitations for oral contracts. Now, something that you need to be aware of, they call it tolling. I call it resetting the debt. So a client called the other day and they said that they were talked into paying a $5 fee to stop the debt collector from calling them over and over and over again. They were just like, hey, just pay $5 and then, we'll call you next month, see if things are good. The problem with that is that when you do that, in some circumstances, you are resetting the statute of limitations, because remember I said the last payment on the debt. If you make a $5 payment, a $1 payment, and it's the last payment date, and you just reset the debt. Now, if you were not aware of it, there is circumstances or situations where you can notify the debt collector and say that you believe that they're in violation of the Fair Debt Collection Practices Act by having you reset the time frame on that debt. Now, they might say, well, it's not past the statute of limitations because, we have another year on that, but they worked real hard to get you to go ahead and make a payment so they can extend that period of time. But you can write to them, and I would say send it in a certified letter and say that your representative misrepresented what the payment was actually for. We all know a $5 payment on a debt is not putting a dent on a debt. Having someone make a $5 payment is, I would just say, if you were to just say what would be the reasoning behind it, is to reset the statute of limitations time frame. So, and then we talked about, but I want to review this too. Statute of limitations for collecting debt is different than the statute of limitations for having information remain on your credit reports. That is a different statute. That's the Fair Credit Reporting Act, which is 7 years on a negative or positive account, and the statute of limitations to collect the debt. So you could actually have a debt that's past the legal statute of limitations to collect and still be on your credit reports legally. Now, you could do something about it, but it could legally still be reported on your credit reports. That is one of the biggest frustrations that I have. I just had a client yesterday that was like, man, this debt is past legal statute of limitations for them to be able to collect, and they're still reporting it on my credit reports, and they updated it on my credit reports. And I said, well, you got to take action. Like, don't leave it up to the bureaus to do stuff for you. They're not in the business of doing stuff for us. They actually stated this. One of the, in a video that I put, I think it was with Equifax, president of Equifax, CEO of Equifax said that it is the responsibility of us to make sure what is accurate on our credit reports. Of us, not them. They take information from furnishers, they get input from us, and it's up to us to make sure what is on there is reported accurately. And then again, just to reiterate, legal actions from debt collectors. Debt collector cannot threaten to sue you for a debt that is past legal statute of limitations to collect. Debt collector must inform you that they're attempting to collect a debt that is past the legal statute of limitations. They will usually use the word time barred when they make that call, but they have to do that. They may not do it. You can check your credit reports, and on your credit reports from the last payment date, if that debt is past the legal statute of limitations to collect, that debt collector is in violation if they know it or not. It is their responsibility to find that out, especially if they've purchased the debt. It is their responsibility to, number one, notify you that they're attempting to collect a debt that is past the time barred. That's the words that they must use, time barred debt. All right. Let me just look through my notes to make sure that I got everything for you. And I think I did get everything for you when it pertains to statute of limitations. For collecting debt that's past legal statute of limitations to collect. If you need help with your credit, please visit us at thecreditrepairshop.com. Watch the video, What Makes a Difference, so you can see my 8-point validation process, my 2-phase settlement process. If you need your credit reports and scores, go to the website, scores.com to grab your TransUnion, Equifax, Experian, credit reports, and all 3 scores. And in that reports that we provide from that provider, it will state the last payment activity. That is very important when you will, and how you will find out if the debt is past legal statute of limitations to collect. If you have debt collectors coming after you early in the game, I give you a letter, statute of limitations letter. If a debt is past the legal statute of limitations for a debt collector or original creditor to collect, you do not have to ask for a debt validation. You just need to notify them in writing, and you need to send that certified mail. I give you that letter. I also give you a debt validation letter and a cease and desist collection activities letter, just in case the debt is not past legal statute of limitations to collect. This will ask them questions to make sure that they have all of the information to collect on that debt. This is mainly used for third-party debt collectors.